contained in its notice of refusal to amend, dated the 21st day of February 2023, and served on the appellants on the 27th February 2023. By a letter dated the 6th December 2022, the respondent imposed additional tax of 276,230,926 naira 58 kobo for the 2020 and 2021 years of assessment on the appellant as follows. Pay tax 109,315,427 naira 73 kobo. Withholding tax 136,693,388 naira 85 kobo. Economic development levy for staff 22,100 naira. Economic development levy for organization 200,000 naira. Urban development levy 18 million naira. Penalty for non-filing of new customers' accounts 12 million naira, giving a total tax liability of 276,230,936 naira 58 kobo. Being dissatisfied or aggrieved with the NORA, the appellant has appealed to this tribunal on the following grounds. I think for a time, we just take it as read. We set out the grounds of appeal and the particulars. There are 5 grounds of appeal and the particulars. The facts. Is a registered company under the Companies and Allied Matters Act 2020 and is licensed to carry on the business of banking in Nigeria. On the other hand, the respondent is an agency of the Akwa Ibom State Government, empowered with the authority to administer all relevant tax laws applicable in Akwa Ibom State. The respondent had, by a letter of the 25th August 2022, notified the appellants of its intention to carry out audit exercise on the appellant for the 2020-2021 years of assessment. After the audit exercise, the respondent, by a letter of the 13th December 2022, raised an assessment of 276,230,926 naira 58 kobo on the appellant. The appellant, through an email of the 13th January 2023, to which the letter dated 10th January 2023 was attached, objected to the assessment of 13th December 2022. The appellant's case is that the respondent overstated the emoluments of the appellant's employees by the inclusion of superannuation and undisclosed income, both of which income the appellant did not pay its employees for both 2020 and 2021 years of assessment. The respondent also understated the appellant's payee tax remittances for 2021 by the sum of 80,695 naira only, and also failed to provide any basis or supporting evidence on how it arrives at the superannuation and undisclosed income. The appellant provided all the information requested by the respondents to audit and determine the extent of the appellant's compliance with his withholding tax obligations, including the interest expense ledger showing the transactions between the appellants and his customers in Akwa Ibom State. The respondent's computation of the appellant's withholding tax liability has no nexus to the information and records supplied by the appellant to the respondent, and the respondent also failed to identify the agents to whom the appellant paid commissions, and in respect of which withholding tax was charged. The respondent did not also identify the appellant's contractors and suppliers to whom fees were allegedly paid, and for which the appellant failed to remit the relevant withholding tax. The appellant fulfilled its obligation and filed the relevant returns of his new customers for 2020 and 2021 as duly acknowledged by the respondent. On development levies, the appellant has remitted the correct amount as provided for economic development levy under the Taxes and Levies Act, and has no further obligation to pay any other economic development levy for 2020 and 2021 respectively. The respondent, through his reply filed on the 18th September 2023, acknowledging receipt of the notice of appeal, accordingly joined issues with the appellant. Hearing in this appeal commenced on the 10th April 2025, and Mr. Adebusi Adedoko, manager and chartered accountant with Anderson Nigeria, tax consultant to the appellants, testified for the appellants. A total of 7 exhibits were tendered in support of the appellant's case. For the respondents, Mr. Akpanobo Sunday Umo, the head, tax audits and investigation, Ezekiel Demanku, chartered tax practitioners and consultants, on recovery and enforcement, adopted his witness statement on oath of the 18th September 2023 and testified for the respondent. Both parties exchanged their final written addresses and subsequently adopted same on the 10th September 2025, and the appeal was adjourned to today for judgment. The appellant formulated the following 3 issues for determination, and they are as follows. A. Whether the respondent's BOG assessment is arbitrary, vindictive, and inconsistent with the provisions of applicable laws. B. Did the respondent's reliance on the evidence presented by the appellants establish and prove the respondent's claim against the appellant? C. Is the appellant liable for penalty and interest for failure to file the accounts of the new customers and object to the tax assessment within the time prescribed by law? On the other hand, the respondent postulated the following 2 issues for determination. 1. Whether having regard to the evidence on record, this appeal is not premature and incompetent on the basis of the appellant's failure to prove that all conditions precedent to the execution of this appeal were met. 2. Whether the appellant has discharged the burden of proving that the respondent's additional assessment is arbitrary, unreasonable, or excessive. It is a view of this tribunal that from the 5 issues formulated by the parties, the following 3 will sufficiently determine the issues in contention. 1. Whether having regards to the evidence on record, this appeal is not premature and incompetent on the basis of the appellant's failure to prove that all conditions precedent to the execution of this appeal were met. 2. Whether the appellant has discharged the burden of proving that the respondent's additional assessment is arbitrary, vindictive, unreasonable, or excessive, and inconsistent with the provisions of the applicable laws. 3. Whether or not the appellant is liable to penalty and interest for failure to file the accounts of his new customers. Submission of the parties on the issues. The appellant. On issue 1, raised by the respondent in his reply of the 9th September 2025 to the appellant's final written address, that this appeal is premature and incompetent because the appellant did not exhaust all conditions present before filing this appeal. The appellant submitted that the position of the respondent is flawed because by paragraph 18 sub 1 of the 5th schedule to the Federal Inland Revenue Service Establishment Act 2007, a person agreed by an assessment or demand notice or agreed by any action or decision of the tax authority may appeal against such decision or assessment or demand notice within the period stipulated under the schedule to the FRS Act. It also refers to Order 3.1 of the Tax Appeal Tribunal Procedure Rules 2021, which provides as follows. A person agreed by an assessment or demand notice made upon him by a state or agreed by any action or decision of the tax law referred to under paragraph 11 of the 5th schedule to the Act may appeal against such action, decision, assessment, or demand notice within the period stipulated hereunder. The appellant therefore relied on the case of Wando Supply and Trading Company and Trading Limited against FBIRO 2001 4 tax law reports of Nigeria 113 and submitted that taxpayers need not wait on the Federal Inland Revenue Service or any tax administration and revenue agency to issue a NORA before filing appeals at the Tax Appeal Tribunal. A NORA is therefore not a condition precedent to be fulfilled before maintaining an appeal, before maintaining a valid appeal against the tax assessment. To be fulfilled before filing an appeal. before filing, maintaining a valid appeal against a person. The appellant further submitted that the respondent's reliance on section 8(3) of the PITA as creating a condition precedent to be fulfilled before an appeal can be filed is misconceived and wrong. The appellant also submitted that nevertheless, by section 68(1) and 2 of the FIRS Establishment Act 2007, the provision of section 58(3) of the PITA, which are inconsistent with the provision of FIRS Act, are void to the extent of its consistency. The appellant also submitted that the case of Stanley Adiga Achukwe against Chief Odi Benedicts and others, 2025, LPELR 81236, decided by the Court of Appeal, referred to by the respondent, is inapplicable to this appeal because it deals with chieftaincy matters. In that case, the Court of Appeal had to interpret and apply the provisions of section 23 sub 3, 4, and 5 of the Benue State Council of Chiefs and Traditional Councils law, which provides as follows. Section 23 sub 3. Any person dissatisfied with the process of selection shall first explore all traditional avenues available for dispute resolution. 4. In the case of failure to resolve the disputes through traditional avenues, the governor, after due inquiry and consultation with the persons concerned in the selection, shall be the sole judge as to whether the selection and appointment of a chief has been done in accordance with the provision of law. Then sub 5, where the agreed parties in paragraph 4 above are not satisfied, they may seek redress in the court of competence jurisdiction. On issue 2, the appellant's counsel submitted that a tax assessment is arbitrary where there is no legal or evidentiary basis for imposing it. And he gave the definition of arbitrary to mean an action which is based on chance rather than being planned or based on reason. He cited the case of Federal Board of Inland Revenue against J.A. Omotosho, 2012, 8 TLRN 88 at page 892, where MB Belgoro J, as he then was, held that in reaching an assessment, the taxman must act dishonestly or must not act dishonestly or vindictively or capriciously, because he must exercise judgment in the matter. He must make what he honestly believes to be a fair estimate of the proper figure of assessment. And for this purpose, he must be able to take into consideration local knowledge and repute in regard to the assessee's circumstances and his own knowledge of previous returns by an assessment of the assessee and all other matters which he thinks will assist him in arriving at a fair and proper estimate. Counsel further submitted that the BOJ assessment is inconsistent with applicable laws because the respondent did not provide a basis for the BOJ assessment. He contended that in arriving at the additional paytas in the BOJ assessment, the respondent overstated the gross emoluments paid to the appellant section for the following reasons. A. The respondent included superannuation as an income line in his additional paid tax computation. B. The respondent included undisclosed income in computing the paytas. While the appellant laid evidence in denial of making such payments, the respondent did not provide any evidence of basis for the undisclosed income referred to in his BOJ assessment. On the contrary, the appellant provided his annual payroll for the period showing actual employment duration, breakdown of allowances paid to the staff, and the gross income earned. 3. The respondent understated the appellant's payee tax remittances for the period of assessment and refused to make the necessary adjustments. They proceeded to issue a NORA. On the withholding tax BOJ assessment, counsel submitted that the BOJ assessment was without any basis because the respondent has not shown that it requested for any information or documents which was not provided before it issued the BOJ assessment. On the contrary, the appellant laid evidence to the effect that he deducted and remitted withholding tax on all transactions with his customers in Akwa Ibom State. C exhibits UBA 6A and exhibit UBA 6B. He cited Section 54, 1 to 3 of Personal Income Tax Act and submitted that the use of the word best in this section presupposes that the respondent's judgment must be based on sound analysis and careful consideration in line with the principles of natural justice and must reflect the reality as reasonably possible. Counsel further submitted that the UBA 1 traces the allegation of under-deduction and non-remittance of taxes. He said that the respondent's sole witness, Mr. Umar, when asked under cross-examination to identify the documents used by the respondent in his BOJ assessment, failed to mention any, though the witness insisted that the respondent has a collaboration with the Federal Inland Revenue Service to have access to audited financial statements. The appellant does not concede to the fact that the respondent obtained the audited financial statement from the FRS, which influenced the BOJ assessment, and insisted that the respondent has an obligation to provide the appellant's audited financial statements to the tribunal and depose to the facts in the respondent witness statement on post of the documents used in arriving at his BOJ assessment. The appellant referred the tribunal to the case of Amadu against Governor of Kogi State, 2009, 1 TLRN 319, and submitted that it is tried in tax law that the taxpayer must be informed with a degree of certainty the basis for any imposition or assessment of tax issued to such taxpayer. The appellant submitted further that evidence given on facts not pleaded goes to no issue and should be disregarded by the tribunal and relied on the cases of Emogokwe Okadibo 1973, 4 SC 113. AG Kwara State against Allow 2007, 9 Nigeria Weekly Law Report Part 671, 84, Happy 84, and the case of Odogo, Fuleku, and Attorney General of Oyo State, 1996, 10 WL Part 477, at page 190, Supreme Court decision. On the payee remittances, the appellant referred to Section 81 of the PITA and submitted that the evidence before the tribunal indicates that the appellant complied with the provisions by filing exhibits UBA 7A and 7B, that is the appellant's annual returns. Evidence led also indicates that the appellant provided a staff payroll, is UBA 4A and 4B to the respondent and paid cumulatively 44,344,738 naira 27 kobo in exhibit UBA 5A and 47,720,435 naira in exhibit UBA 5B. Counsel the appellant concluded his submission on this by stating that in spite of the remittances, the respondent still raised a BOJ assessment of 109,315,427 naira 73 kobo for the 2020-2021 year of assessment. On the withholding tax remittances, counsel cited Section 70 of 3 and 4 of the Personal Income Tax Act and submitted that the only information required to determine the withholding tax on interest payable to savings account in any state is information related to savings account maintained in the appellant's branches in that state. The receipts evidencing withholding tax remittances, that is exhibit UBA 6A and 6B, show that the appellants remitted 53,129,198 naira 57 kobo for the 2020 financial year and 21,051,769 naira 68 kobo for the 2021 financial year. The appellant also paid, as shown on exhibits UBA 6A and 6B, 785,000 527 naira 63 kobo as withholding tax on commission receipts for the 2020 financial year, and 186,457 naira 72 kobo as withholding tax on commission receipts for the 2021 year financial year. In spite of all the above payments, the respondents did not consider these remittances and proceeded to raise additional assessment of 136,693,398 naira on the appellant without justifying same. The appellant referred to the all-reported case of United Bank for Africa PLC against Kaduna State Internal Revenue Service. The appeal number is cited TAT Northwest Zone Kaduna withholding tax 073-2022, where the tribunal held that a tax authority must show that the imposition of this BOJ assessment is justified. The appellant also submitted that the respondent did not identify the agents to whom the appellant paid commissions, and in respect of which withholding tax was charged. The respondent also did not identify appellant's contractors and suppliers to whom fees were paid, and in respect of which the appellant failed to remit the related withholding tax. The appellant provided the statutory documents required for assessment, and the respondent cannot validly subject the appellant to BOJ assessment after the necessary documents were provided to the respondent. The appellant further contended that a tax authority is empowered to make additional assessments only where there is discovery of new facts and issues, and refer the tribunal application of Mobile Oil Nigeria Limited against Federal Board of Inland Revenue 2011 5 TL RON 167 IPDs 207 and 231. The appellant concluded his submissions by stating that the respondent's additional withholding tax and the payee tax assessment are not valid because the respondent has not been able to show that there was discovery of new facts or information such as interest payments by the appellant to his customers, which were not previously disclosed. The appellant therefore urged the tribunal to set aside the BOJ assessment as it did not meet the required statutory standard. On the tutorial as to whether or not the appellant is liable to penalty and interest for failure to file the accounts of his new customers, the appellant submitted that there is no basis for penalty and interest as the penalty that would, as the appellant had fulfilled its obligation to file the returns of the new customers as evidenced by exhibits UBA 7A and 7B. The appellant submitted that the respondent's witness, Mr. Umo, during cross-examination, identified the respondent's stamp on exhibits UBA 7A and 7B respectively on the 29th January 2021 and 28th January 2022. The appellant also submitted that it is not liable to pay penalty and interest because it objected to the assessment within the time prescribed by law. The appellant relied on the case of Amadu against the Governor of Kogi State, 2009, 1 TFRO at page 319, and submitted that there is no legal basis for subjecting the appellant to penalty and interest because tax liability is determined in strict compliance with extant and express provisions of the law, and not by inference or implication. The appellant referred the tribunal to two cases of Weatherford Services against FIRS 2016, 26 TLRN at page 44, and Tetra Pak West Africa Limited against Federal Inland Revenue Service, 2016, 24 TLRN 95 at 107, where the tax appeal tribunal held that under paragraph 18 of the fifth schedule to the FR Establishment Act 2007, computation of penalty and interest on additional assessment is allowed only when the assessment or demand notice have become final and conclusive. If a taxpayer fails to file an appeal or objects within 30 days after the order or demand notice being appealed against was made. The appellant concluded the submission on this issue by submitting the appellant objected within time as shown on exhibit UBA 2 and UBA 3, and also filed this appeal before the expiration of 30 days. Now the respondent. On issue 1, the respondent submitted that where a law designates a condition precedent or procedure for activating an action or right, that procedure must be strictly followed and refer the tribunal in the case of Abubakar, case at the General of the Federation 2008, all FWLRO Part 441, S70 at page 908, paragraph B. And Eli International Limited against Umar Ali and Co. Nigeria Limited, 2022, 18 NWLRO Part 1862 at page 401. The respondent submitted further that tax laws are strictly construed and interpreted narrowly and relied on the cases of FBIRO against Halliburton, West Africa Limited, 2016, 4 Nigeria Report Part 51501 at page 53. Submitting for that, the respondent cited the case of Bicotney against Associates and Laws Kilomita and Mother, 2023 to 07 Legalpedia, 43070 Court of Appeal, where the Court of Appeal had that in the sight of the law, a conditional precedent is defined as the one that delays the vesting of the right until the happening of an event. The respondent therefore argued that the right to appeal to the tribunal crystallizes only after the tax authority's refusal of the taxpayer's objection and issues a NORA as provided in section 58 of the Personal Income Tax Act 2011 as amended. He argued for that a NORA is not a mere procedural document, but that it signals an end of the administrative review process and gives the taxpayer the standing to appeal to the tribunal. After referring to the case of Stanley, Achiga, and others, Supra, the respondent submitted that consequently, the tribunal's authority to hear this appeal has not been activated, and that the appeal is premature, fundamentally defective, and should be struck out for being incompetent. He referred to the case of Dada against Yan Daji, 2025. Nigeria Work Weekly Law Report, Patch 1993-517. The respondents concluded on this issue by submitting that the tribunal's jurisdiction is limited to issues which are properly before it. In his further submission, the respondent posited that the appellant did not tender the NORA before the tribunal, and the failure to do so is adverse to the appellant's case, and that the appeal should be struck out. After citing a long line of cases, the respondent submitted that in the absence of the NORA as an exhibit, this appeal must fail. The respondent also submitted that in the absence of a valid appeal, the tax assessment of 276,280,920.58 has become final and conclusive, as was held in the case of Starving Water Petroleum Limited against Lagos State Internal Revenue Service, TAT Lagos Zone 022/2012. The respondent further submitted that by section 58 sub 1 of the PITA, the appellants must show not only that it objected to the assessment, but also that the objection was made within 30 days, and that failure to do so rendered the appeal effective and incompetent. The respondent also made the point that the tribunal is bound by the evidence before it, rely on the case of Lawan, Abdullahi Babu Basa, and 2 others against Tushahe, Kara, and 2 others. LERO 2014, Supreme Court 308/2001, and concluded that, as was held in the case of FRS against Agronis, Nigeria Limited 2025, 1 Nigeria Weekly Law Report by 1974 at 644. Any decision not founded on evidence amounts to a paperless decision. On issue 2, the respondent submitted that in a tax appeal, the burden of proving that an assessment is excessive, arbitrary, or incorrect rests on the taxpayer, and referred the tribunal to the case of Federal Board of Inland Revenue against that ANAS, Supreme Court 205, 1964, NGSC 9. And Mobile Oil Nigeria Limited against FBIRO 1977, LPEIRO 1884 Supreme Court. The respondent further submitted that though the applicant made assertions that the respondent overstated the gross emoluments paid to all the applicant's employees, and also included superannuation and non-disclosed income in its computation, the applicant failed to provide documentary evidence to substantiate the assertion, and that mere assertions cannot substitute for hard evidence, as was held in the case of Felicia Akemi Sade against the state 2006, 17 LWL Part 1007, page 184 and 201. The obligation is on the applicant to provide evidence to disprove the assessment as was said in the cases of Ituama against Agbe in 2012 Legal Report Part 686 at page 156, and Agbola against UPFC 2011 31 EW RON 01 Supreme Court. The respondents also submitted that the assessment was not arbitrary, as alleged by the applicant, but that an assessment is only arbitrary if it lies legal or evidentiary basis, and that the law empowers the tax authority to reach a duty assessment where a taxpayer's returns or records are found to be unsatisfactory or incomplete, and rely on the case of Candlelight Engineering Company against Virus 2023 LPALR 6068 to Court of Appeal. The respondents argued further that the assessment, which is the subject of this appeal, is a product of tax audits which reveal discrepancies, prompting the respondent to form the opinion that additional taxes were due. The figures for superannuation and non-disclosed income were derived from the respondent's professional judgment and analysis of the applicant's records and submission during the audits. The respondent therefore had a duty to make what it honestly believed to be a fair estimate based on the information and findings from the audit exercise. Referring the tribunal to the case of Federal Board of Internal Revenue against K.O. Motesho 2012 LTLRN 89 at page 92. The respondent contended further that the onus was on the applicant to provide complete and convincing evidence during the objection process, and its failure justifies the DOJ assessment under Section 55(1) of the PITA. On issue 3, the respondent submitted that by the imposition of the Economic Development Levy for organization, Urban Development Levy, and penalty for not filing of new customer accounts, the respondent decides its powers under the Economic Development Levy Law of Akwa Ibom State and the Land Use Fee Regulation 2020, while Section 49 sub 4 of the PITA provides for statutory penalty for failure to file new customer accounts. Section 76 imposes a penalty of 10% on the taxpayer for late payment. Furthermore, the Economic Development Levy Law of Akwa Ibom State stipulates a penalty of 5% of the levy for any contravention. The respondent further posited that by paying the Urban Development Levy and Economic Development Levy for 2020 and 2021 in the course of the hearing of this appeal, the appellant has acknowledged that this levy is of legal basis. Now, determination of the issues. Issue 1. On this issue, one of the tripartite contentions by the respondent is that this appeal is premature and should be struck out because the appellant did not wait for the respondents to issue an order before proceeding to file this appeal. Is this appeal premature? Did the appellant need to wait for the respondent to issue an order before filing this appeal? The answer to these questions is not far-fetched. Paragraph 2, sub 1 and sub 2 of the second schedule to the Joint Revenue Board of Nigeria Establishment at 2025 provides as follows. 2 sub 1. A taxable person agreed by an assessment, demand notice, action, decision of the tax authority or a dispute as to residency under the provisions of the tax laws may appeal against such decisions of assessment, such decisions or assessment within the period stipulated under this act to the tribunal. 2 sub 2. An appeal under this part shall be filed within a period of 30 days from the date on which a copy of the assessment, demand notice, action, or decision which is being appealed against, is met or deemed to have been met by the relevant tax authority, and it shall be in such form and be accompanied by such fee as may be prescribed. The plain and natural meaning of the words of paragraph 2, sub 1, quoted above, is that once a taxpayer has agreed with any decision of the tax authority by way of an assessment, action, or demand notice, he can proceed to file an appeal at the Tax Appeal Tribunal. The taxpayer may choose to object to such action, demand notice, or assessment by writing to the tax authority, but this is not mandatory. Even where a taxpayer has written to the tax authority to object, it is not bound to wait for a response from the tax authority before filing an appeal at the Tax Appeal Tribunal. Citing the case of SPDC Nigeria Limited against FBI Weekly, 1996, 8th Nigeria Weekly Report, part 466, page 256, where the wise CJN at page 285 stated that the principle of construction of statutes is that if the words of the statute are precise and unambiguous, they should be given their ordinary and natural meaning. The Tax Appeal Tribunal, in the case of Wando Supply and Trading Co. Limited, against FRS 2013 1 entity LRO for 142 and 154, held as follows. It is clear that the Act does not require a notice of refusal to amend to issue from the tax authorities to the taxpayers before the latter can approach this tribunal for redress. Provisions in other statutes purporting to stipulate any such condition precedent are inconsistent with the Federal Inland Revenue Service Act, and by operation of Section 16 of that Act, void. NORA is not a requisite pre-action protocol for proceedings here. In the Wando case referred to above, the tribunal considered similar provisions of repeals paragraph 18(1) of the 5th schedule to the Federal Inland Revenue Service Act, Assembly Act 2007. It is therefore beginning at this point to emphasize that tax jurisprudence is sui generis. The proceedings are unique and distinct from other aspects of legal jurisprudence. Section 58, sub 3 of Peter, and the case of Stanley Adigat Adupe against Chief Odi Benedict Achi and others relied on by the respondents are grossly inapplicable. The respondent's objection to the competence of this appeal on this ground therefore fails. The second leg of the respondent's objection to the competence of this appeal is that the appellant failed to object to the assessment within 30 days as required by the law. And the assessment has become final and conclusive. What is not disputed in this appeal by both parties is that there was a demand notice dated 13 December 2022 from the respondent to the appellant, in which the respondent raised a tax assessment of 276,230,920 naira 58 kobo. See paragraph 6 and 7 of the appellant's witness statement on oath of 28 March 2023, and paragraph 7 of the respondent witness statement on oath of the 19th June 2023. Both witness statements were adopted by the parties in evidence in the course of the proceedings. The demand notice dated 13th December 2022 and received by the appellant on the 15th December 2022 was tendered in evidence as Exhibit UBA 1. On the 10th January 2023, the appellants objected to the demand notice, that is Exhibit UBA 3. An acknowledgement stamp of the respondents on the face of Exhibit UBA 3 shows that the respondent received it on the 6th February 2023. Nevertheless, the appellant had by email sent the objection to the respondent on the 13th January 2023 through the respondent's official email address info@akwaibomstate.gov.ng and akiros.ng@gmail.com. That is exhibit UBH. It is worthwhile to note that the respondent has not denied ownership of the two email addresses stated above. It is a service of the objection through the official email addresses of the respondent, proper service and sufficient the circumstances of this case? We think so. In the case of Earth Moving International Limited against Federal Land Revenue Service 2022, 3 NTT LRO 104 at 111. The tax appeal tribunal held as follows. The appellant in this appeal sent a notice of objection to the tax controller, Lagos Zone of the FIRS on the 27th day of September 2018 via his email address today@firs.gov.ng and a delivery receipt notification equally received. The tax controller Lagos Zone of FIRS, being a very senior officer of the respondents, receipt of the email by him equally translated to receipt by the respondents. In the light of the foregoing, the appellant had duly filed their notice of objection within the time frame permitted by law. In the circumstances of this appeal, the objection to the demand notice served on the respondent through his official email addresses is proper and sufficient service. The appellant also objected to the demand notice within 30 days as stipulated by law, because the demand notice was issued on the 13th December 2022, and the objection was dated January 2023, but sent through email on the 13th January 2023, which is within 30 days. The objection as to the competence of this appeal on this ground also fails. The third reason for the respondent's objection to the competence of this appeal is that the appellant failed to tender the NORA as exhibit in this appeal. Has this rendered this appeal incompetent? We don't think so. The appellant grounds of appeal are self-explanatory. The appeal is against the respondent's imposition of PE, withholding tax, economic development levy for staff and organizations, and penalty and interest. As was decided earlier by this tribunal in this appeal, the appellant did not have to wait for the respondent to issue a NORA before proceeding to file this appeal. Failure to tender the NORA in evidence is therefore immaterial and does not affect the competence of this appeal. In the final analysis and in view of the earliest conclusions reached by this tribunal, the answer to issue 1 is in the negative. This appeal is not premature and incompetent, and the respondent's objection fails and is overruled. Issue 2. Paragraph 7 sub 5 of the second schedule to the Joint Revenue Board of Nigeria establishment of 2025 provides as follows. The onus of proving that the assessment complained of is excessive or due for payment, as the case may be, shall be on the appellant. In compliance with the above provision and in an effort to discharge that burden of proof, the appellant tendered exhibits UBA 4A, that is staff payroll for 2020, UBA 4B, staff payroll for 2021, UBA 5A, payee remittances for 2020, UBA 5B, payee remittances for 2026A, withholding tax remittance for 2020, and UBA 6B, withholding tax remittance for 2021, respectively. The above exhibits were to support his position that the respondent had understated the payee and withholding tax remittance from the appellant. In the course of the hearing of this appeal on the 16th July 2025, the appellant drew the attention of this tribunal to an affidavit of facts filed by the appellant on the 14th of July 2025 to the effect that the appellant had on the 14th day of June 2025 made a payment of 18,200,000 in favor of the respondent. The payment represented 18 million naira for urban development levy and 200,000 naira for economic development levy for organizations, and the UBA transaction receipt was attached accordingly. The respondent acknowledged the payment. After painstakingly studying and comparing the staff payrolls, that's the UBA 4A and 4B, the remittances is the UBA 5A and 5B, and withholding tax remittances is UPA 6A and 6B for 2020 and 2021 respectively. The tribunal has noted the following. Review of payee withholding taxes for 2020 and 2021. 1. Payee remittances. Payee remittances receipts duly entered into the schedule with arithmetic accuracy. However, the following payee receipts were omitted in 2021 schedule. 2021 payee remittances omitted from remittance schedule. We have listed the receipts. We have listed out the remittances that were omitted from the schedule. I take it as read. That is amounting to a total of 8,694 naira 33 kobo. Then number 2, withholding tax remittances. In 2020, withholding tax amounting to 53,129,138 naira 57 kobo paid by the applicant was omitted from the schedule and consequently from the demand notice, thereby overstating the assessment. Also for 2021, withholding tax amounting to 21,051,769 naira was omitted and resulted in overstated assessment. 2020 withholding tax remittances omitted from the remittance schedule. Receipts, we have listed them. Totaling 53,129,138 naira 57 kobo. Then we also have 2021 withholding tax remittances omitted from the remittance schedule. We have listed them. Totaling 21,051,769 naira 68 kobo. Number 3, payroll 2020 and 2021. The payroll for 2020 and 2021 used for the demand notice assessments, appendix 1 and 2, were exhibits of the appellants that acquired from the appellant. That is the exhibits of the respondents. The following were tendered by the appellants. The following were the variables of the payroll. We have listed out the variables of the payroll and some of the significant things we noticed that there were ridiculous days of employment. There were ridiculous days of employment. For example, 2020 employee of serial number 7, the Mail's date of employment was January 2047. And the same thing for several employees, including 2021. Then the number of months we have, our comment is that it's incompressible figures, the figures are incompressible. And we have listed them. We have listed them out there. And then we have listed the breakdown of consolidated relief. We have listed following the error in the application of consolidated relief and the application of the number of months worked, some employee were overcharged. For example, 2021 payroll, serial number 111, the revenue force was charged by 83,560 naira 61 kobo, while the correct payee for the 2 months worked was 531,088 naira 31 kobo. This employee payee under-deducted, it was under-deducted by 148,127 naira 70 kobo. We have a summary of the revised summary of tax liabilities for the year 2020 and 2021. We have the summary. Appendices is attached. You will see it in the judgment. All these details are in the judgment. We have 2021 withholding tax remittances appendices omitted from remittance schedule. We have them. You see them in the. Those are the appendices we refer to. You see them in the judgment. And then we say from the above analysis and computations, it is obvious that some of the payee and withholding tax remittances made by the applicant were not captured by the respondent in his computations, thus leading to understating the applicant's remittances and excessive assessment of the applicant's additional tax liabilities. The tribunal is empowered, after hearing both parties, to confirm, to reduce, to increase, or annul the tax assessment. Paragraph 7 sub 8 of the second schedule to the Joint Revenue Board of Nigeria Establishment Act 2025 provides as follows. The tribunal may, after giving the parties an opportunity of being heard, confirm, reduce, increase, or annul the assessment, or make any such order as it deems fit. In the exercise of the powers, in the exercise of the above powers, and in furtherance of the earlier computations made, the tribunal has arrived at the following conclusion as to the actual additional tax liabilities of the appellants. Unremitted payee liability 103,711,552.59. Unremitted withholding tax liability 31,403,685.991. Unremitted penalty for non-filing of new customers' accounts 12 million, giving a total of 147,115,238.50 naira. From the above premise, this tribunal finds and holds that a sum of 147,115,238.50 naira is outstanding and payable to the respondent by the applicant, representing unremitted payee, withholding tax, and penalty for non-filing of new customers' account for 2020 and 2021, respectively. On issue 3, which relates to the penalty of 12 million naira for non-filing of new customers' account, the applicant maintained that it fulfilled its obligation and filed the relevant returns of its new customers with the respondent, and tendered exhibits UPA 7A and 7B for 2020. But the evidence before the tribunal shows otherwise. Even the evidence of the appellant's witness under cross-examination on the 10th April 2025 does not support the assertion of the appellant that he complied with Section 49 of PITA to file his monthly returns for new customers. For the avoidance of that, this is what transpired between the appellant witness and the respondent counsel during cross-examination. Respondent counsel, you have evidence for penalty for not filing of new customers' account for 2020-2021. The appellant witness, there is no evidence of remittance for penalty for 2020 and 2021 because the returns were filed as an due. Respondent counsel, by virtue of Section 49 of PITA, you are aware that the appellant ought to file his monthly returns of the new customers. The appellant witness, yes, I'm aware that the appellant should file returns for his new customers, to which the appellant has complied. The appellant, the respondent counsel, by your response, exhibits UBA 7A and 7B, is that the monthly returns for new customers of the appellant? The appellant witness, none of the exhibits relate to filing of new returns. Now, exhibits UBA 7A and 7B, tendered by the appellant as proof of his compliance with the requirement to file monthly returns for his new customers, is in actual fact the annual returns for 2020 and 2021, which did not relate to new customers' accounts. Section 49 sub 2 of the Personal Income Tax Act, as amended by the Personal Income Tax Amendment Act 2011, provides, Section 49(2), without prejudice to Section 48 of this Act, a person engaged in banking shall prepare a return at the end of each month, specifying the names and addresses of new customers of the bank, and shall not later than the 7th day of the next following month deliver the return to a tax authority of the area where the bank operates, or where such customer is a company to the Federal Inland Revenue Service. From the above premise, the appellant has not discharged the burden of proving that he complied with Section 49 sub 2 of the PITA. The respondent was therefore in order, which is raised a penalty of 12 million naira for non-filing of new customers' account for 2020 and 2021. it is therefore for the finding of this tribunal that the appellant is liable to pay 12 million naira to the respondent as penalty for not filing for new customer account for 2020 and 2021 years of assessment. It is on record that in the course of the hearing of this appeal, the appellant paid to the respondent 18,200,000 naira, being urban development levy 18 million and economic development levy for the 200,000 naira for the 2020 and 2021 years of assessment. In the final analysis, therefore, this tribunal finds and holds as follows. A. The respondent's objection to the completeness of this appeal is overruled. This appeal is not premature or incompetent because the appellant objected to the respondent's demand notice of 18 December 2022 within the 30 days allowed by law and did not have to wait for the respondent's NORA before filing his appeal. B. The respondent was right and really exercised his powers under section 49 of the Peter as amended to impose penalty of 12 million naira on the appellant for his failure to file new customers account for 2020 and 2021. C. The total of 147,115,238 naira 50 kobo additional cash is due and payable by the appellant to the respondent, being unremitted payee, withholding tax and penalty for not filing a new customers account for 2020 and 2021 years of assessment. This is a unanimous judgment of this tribunal. The parties shall bear their respective costs. Dated this Wednesday, the 12th day of December 2025. Yeah, that's our judgment.
As the tribunal pleases, Mr. Chairman, sir, would want to thank this honorable tribunal for the well-considered judgment.
Yeah. Basi, do you have anything?
Hello, Mr. Chairman, sir.
We can't hear you, Basi.
Okay.
Well, that's our judgment, so take that, right?
Next on the court slate is appeal number T80/FFD/2022. Riser State Board of Internal Revenue versus Continental Orient and Gas Limited.
You have evidence for penalty for not filing of new customers account for 2021. The appellant witness, there is no evidence of penalty for 2020 and 2021 because the returns were filed as agreed due. Respondent counsel, I read from section 49 of Peter. You are aware that the appellant ought to file his monthly returns of the new customers. The appellant witness. Yes, I'm aware that the appellant should file records for his new customers to which the appellant has applied. The appellant, the respondent counsel. By your response, basically CUB and 7A is that the monthly returns for new customers of the appellant. None of these things relate to value of new returns. Now, this is CUB and 7A and 7B. Then that by the appellant as proof of his compliance with the requirement to find monthly returns for his new customers. It's in actual fact the annual returns for 2020 and 2021. Without prejudice to section 48 of this act, the person engaged in banking shall prepare a return at the end of each month, specifying the names and addresses of the customers of the bank, and shall not later than the 7th day of the first following month deliver the return to a tax authority of the area where the bank operates, or where such customer is a company with the federal regulations. From the above premise, the appellant has not discharged the burden of proving that he complied with section 49 of 12. The respondent was therefore in order which raised the penalty of 12 million naira for not filing of new customers account for 2020 and 2021. It is therefore for the finding of this.
Honorable Tribunal. My name is Onume Otia. I respectfully appear for the respondents applicant.
Yeah.
The chairman and honorable members of this tribunal, the applicant has the motion challenging the competence of this appeal. That motion was filed on the 7th of October. That motion was filed on the 7th of October 2025. And the same has been served on the 7th of October 2025. Yes, ma'am. Yes, ma'am.
2025.
7th of October. That is the stamp on my own, yes. Yes, ma'am. Yes.
What do you want to have here? No, let me say this.
It's dated 2nd day of October 2025. Was filed on the 6th by the secretary. On the 7th of October 2025, about 9 6 7.
No, on the 7th.
Yes, Mr. Chairman. And subject
You say dated, I can't see where dated is.
at
You said second.
page 2 of the motion paper is dated 2nd of October.
What I have.
But it's not dated. Oh, sorry, man. Sorry. Well, we'll skip that.
You dated your own and you left the official one.
Maybe it's because of distribution of funds.
So, yeah.
And the tribunal,
When the workers on the appellant, that was great stuff.
yeah, it has been served on the appellant,
Yeah.
and only on Monday, the day before yesterday, I received an electronic,
On Monday,
yes,
Monday, what date?
1st of December,
Yeah.
I received an electronic copy of the counter affidavit of the appellant. In that respect, I will crave the tribunal's indulgence to enable me respond on points of law orally. I still have time to respond, but I don't want to delay these proceedings. So I would like to reply orally.
With the counter,
Yes, because in fairness to the appellant, once I make my reply, we are not entitled to make any further reply. So, because my reply is to close the process.
sorry, and then
To reply Very briefly, not more than 10 minutes on the issues of law raised in the counter affidavit.
Is it not when you move the application that you can now?
No, I'm just putting, I'm laying the cards before the tribunal.
So move the application.
As the
Move
tribunal please.
Keep the card. Move.
Okay.
Well, I can only record it that I intend
Let's
to.
not jump the gun.
I intend
It's okay.
to. What, let me record it that I intend to rejoin.
So that I'm not told that I've not responded orally, writing, and that,
I intend to rejoin on points of law.
yes, sir. To the
To the counter.
counter affidavit. Filed on me only on Monday.
Monday is all, you have your 48 hours.
Sir,
You have your 48 hours.
which expires today. Because it starts from the day after, like,
And so
proceed to the process.
yes, you are waiting the 48 hours.
On the condition that we are allowed to respond orally.
All right.
Why not?
Yes.
If it's legal, why not?
Fine.
Yeah, I'm just
We
making,
should take the conference of law.
yeah, yes, sir.
But
So that when we get there, we're not do that, you slept over, right?
So you want to put that there?
Yes, sir.
Okay,
Ready.
Yes, my lord.
Kevin.
Yes, my lord. My lord, on our part, we did file a counter affidavit. Which is dated and filed on the first day of December 2025, my lord. My lord, it's in opposition to the applicant's motion on notice to set aside the judgment of this honorable tribunal. My lord, our counter affidavit is supposed to by.
No,
I've not moved.
no, we're there.
Oh, okay. So sorry.
respect of the testimony.
So he wants to go on, he wants to move his application. So can you go on?
Yes, my lord, we're ready to go on, and subject to the providing convenience of the honorable tribunal, we're ready to move ourselves. So
Yeah, so, okay, there.
Before this honorable tribunal. Yes.
Yeah.
Applicant's motion. Filed on the 7th of October 2025. The motion 6, 1 relief. Asking this honorable tribunal to strike out this appeal for being incompetent against the respondent.